committee of the whole is called to order without objection. All amendments which have been distributed will not be read in full. Hearing none, so ordered. The clerk will read the first bill on the calendar together with committee recommendations.
Senate Bill 1003. Mr. Speaker, Committee on Health under consideration. Senate Bill 1003 recommends bills do pass. Mr. Speaker, Committee on Rules under consideration. Senate Bill 1003 says bill is constitutional, proper, and in form.
Chair recognizes Representative Cobb.
Yes, Mr. Chairman. I move that when the committee of the whole rises to report, it recommends that Senate Bill 1003 receive a due pass recommendation.
Speaker, Committee on Health is under consideration. Senate Bill 1003 and recommends that it do pass.
Chair recognizes Representative Townsend.
I'm
sorry, Representative Cobb.
Thank you, Mr. Chairman. Mr. Chairman, I move the Health Committee amendment in Carter's name be adopted.
Okay. Representative, is there an explanation?
No.
Okay. Is there any further discussion? Hearing none. Members, the motion before you is the Carter Health Amendment. All those in favor vote aye. All those opposed vote nay. Appears the ayes have it, do have it, so ordered. Representative Townsend.
Thank you, Mr. Chair. I move that when the committee of the whole rises to report, it recommends that my floor amendment to Senate Bill 1003 be adopted.
Okay. Explanation?
Thank you, Mr. Chair. All this does is just stipulates that we cannot use the covert or overt, use of the stress analysis during investigation, and that it cannot be entered into the record at all.
Okay. Is there any further discussion? Hearing none. Members, the question before you is the Townsend floor amendment number 1. All those in favor vote aye. All those opposed vote nay. Appears the ayes have it, do have it, so ordered. Representative Townsend.
Thank you, Mr. Chair. I move to retain the floor amendment number 2.
Just, Representative, just don't offer it. We'll just go on to the next one.
All right, we're not going to offer. Okay. All right, so, Mr. Chair, I move that when the committee of the whole rises to report, it recommends that the Townsend number 3 floor amendment to Senate Bill 1003 be adopted.
Okay, is there an explanation?
Yes, Mr. Chair. What we're trying to do at the Department of Child Services or Safety is to start to look at whether or not the department needs to obtain a warrant prior to going in and removing a child when there is not exigent circumstances. And this is an ongoing conversation that's been had, and last week we visited this. In the meantime, I contacted the department and asked them, I've already asked them how many warrants did we get last year, and the answer was 0. And I asked the second question, okay, then how many court orders did the department receive prior to the removal of a child in a non-exigent circumstance last year? And I have not been able to get the answer to that question. So I think it would be a good practice that we ask that the department submit on a quarterly basis the number of non-exigent removals of children that a court order was obtained prior to going and removing the child, so that we can, as we go through this next year, study the trends and what this looks like so we can make proper decisions when we put forth legislation next year.
Okay, the chair recognizes Representative Espinoza.
Mr. Chair, thank you. Good afternoon. Mr. Chair, I'm concerned of a quorum.
Okay, give me 1 second.
Thank you.
Come on, man. This was going to be really easy.
We have a quorum. Okay. Is there any further discussion? Chair recognizes Representative Rios.
Thank you, Mr. Chair. I rise in support of the Townsend number 3 amendment. I commend Representative Townsend for this amendment, and I agree with her, and not only with regard to this issue, but I think there are a number of other issues that DCS should be reporting to us on an ongoing basis. At the end of the day, this, I think, is one of the most important departments that we have in government, is protecting the children of Arizona, and so I rise in support of the Townsend amendment.
Thank you. Is there any further discussion? Hearing none. Members, the question before you is the Townsend floor amendment number 3 be adopted. All those in favor vote aye. All those opposed vote nay. Appears the ayes have it, do have it, so ordered. Representative Townsend.
Thank you, Mr. Chair. I move with that when the committee of the whole rises to report, it recommends that my floor amendment to Senate Bill 1003 be adopted.
Is there an explanation?
Yes, members, this is another amendment that deals with a situation regarding caseworkers failing to disclose known exculpatory evidence, fabricating evidence, withholding material information, or lying about a matter to the courts. And one would think that this isn't a problem, that we shouldn't, this is a given. However, we had the Auditor General in 2015 disclose to us in their report that caseworkers readily admitted that they had made up their minds prior to going to the meeting with the parent, when the parent would present their exculpatory evidence, that they had already made up their mind whether or not they were going to remove the child, regardless of what that evidence may or may not be. We had just this year, October of last year, we had the Ninth Circuit entertain an argument from an attorney for caseworkers who was trying to argue that it's impossible for the caseworkers to know and understand that you cannot lie on on the paperwork or to the court. And of course, the Ninth Circuit did not buy that argument. So this is a given, but however, because we have had situations in the past where the caseworkers are not looking at that information, or perhaps making their decision before, I think it's important that we put into statute that that is not allowed.
Okay, the chair recognizes Representative Bolding.
Thank you, Mr. Speaker. Thank you, Mr. Chairman. I'd like to make a comment on the Townsend 4 floor amendment.
Yes, proceed.
Thank you. I do rise in support of this floor amendment. And in conversation, this has been with constituents. This has been one of the major areas in which constituents have felt that they are not really receiving fair and accurate information that's being told with regards to their case. Recognizing that the process, in many cases, it requires DCS employees to actually look for information to confirm in one of the 17 different areas in which they have to remove a child. It actually almost requires them to look for and search for information, search for evidence to actually confirm what they suspect. In many cases, it could potentially influence an outcome for juveniles and really put them into a system that's, breaking across families. So I would actually even love to see the amendment move forward and even further and have this apply to any supervisors who actually know that information as well to not be true. But as it stands, I do support the Townsend 4 floor amendment. And again, I would even push for stronger language within supervisors who may know this information as well. With that, thank you.
Okay. Is there any further discussion? Hearing none. Members, the question before you is the adoption of the Townsend number 4 floor amendment. All those in favor vote aye. All those opposed vote nay. Appears ayes have it, do have it, so ordered. Representative Cobb, we're back on the bill as amended.
Yes, Mr. Chairman, I move that when the committee holds rise to report, it recommends that SB 003 as amended receive a due pass recommendation.
Okay, is there any further discussion? Hearing none. Members, question before you. So when the committee of the whole rises to report, gives Senate Bill 1003 as amended a due pass recommendation. All those in favor vote aye. Whoa. Pause.
substitute. Mr. Chairman. To have it pass. I knew she was. Mr. Chairman.
Chair recognizes Representative Cow.
I'd like to make a substitute motion to retain SB 1003 on the calendar.
Chair recognizes, can I go? Chair recognizes Representative Townsend.
Thank you, Mr. Chair. I offer a substitute motion to the substitute motion, if I said that right, that when the Committee of the Whole rises and report, it recommends that Senate Bill 1003 as adopted be given a due pass recommendation. Excuse me, as amended.
So the Diamondbacks are off to a good start, huh? Members, the ruling of the chair is that the last motion was not in order. We have the motion on the floor, which is Representative Cobb's, which is up for debate.
The last one, number 4.
Maybe I misunderstood. She said, I thought they didn't want any amendments on it.
We're all good.
About the reports,
Can-
like the other two.
Did you want?
Is there any further discussion? Representative Townsend.
Thank you, Mr. Chair. Ordinarily, I would yield in a situation like this. However, at this time, I'm not willing to yield because of the content of these amendments. I have the sponsor agreeing to Amendment 3 about getting reports from DCS telling us how many, well, they didn't get any warrants last year. They won't tell us how many court orders they got, and this would be regarding protecting a person's Fourth Amendment right. Last week we heard testimony that the Fourth Amendment didn't apply when you went in to protect somebody, giving an order of protection. I'm going to read the Fourth Amendment. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. We're afraid that if we institute warrants, then a child dies in the meantime, that somehow now the public is going to be angry at us for that because the pendulum swings back and forth between taking too many children and not taking enough. And we're following the pendulum based on the public opinion of what we should be doing. I don't follow a pendulum. I follow the Constitution, and each one of us raised our hands to support and defend it. So I'm glad that the sponsor is okay with at least asking DCS, how many court orders at least did you get when you removed children in a non-emergency? Because they certainly did not get any warrants. The amendment that is not acceptable is that a DCS worker shouldn't lie, that a DCS worker shouldn't withhold exculpatory evidence that the parent's trying to prove themselves innocent, and you can see the other items on there. I'm not sure why we're not okay with that. Which one of you is going to vote that it's okay for social workers to lie in order to remove a child? Why are we not okay with that amendment? Members, I understand the protocol of when the sponsors feels that it's a hostile amendment, and I've always respected that. In good conscience, I cannot respect that today. This needs to be done. Our DCS agency needs to be held accountable. When I put in a fiscal note to ask DCS how much would it cost you to have to implement the Fourth Amendment, I was ignored, completely ignored. The courts answered back and they said they didn't know, but it would be significant. Members, at some point, we're going to have to stop operating off of fear and public opinion, and we're going to have to respect the Constitution, a person's Fourth Amendment right, which, by the way, has nothing to do with soldiers bursting into your house, as was testified last week. That's the Third Amendment. The Fourth Amendment means that we do have the right to be secure in our persons. I think it was Benjamin Franklin who said that those who would trade safety for their rights deserve neither. And it's an emotional topic when we're talking about kids. But it's also, I can't tell you how many people have come to me begging for justice, begging for due process, and have not received it. I personally have been involved in a case that I have been gagged on, that I have information that makes it so I can't sleep at night, of what's happened to one of our Arizonans at the hands of DCS. I want this agency to operate legally and effectively. And I understand if you can't support my request, but I have to be able to look at myself in the mirror, and I have to be able to answer my constituents. Thank you.
Okay, members, is there any further discussion? Seeing none, members, the question before you is that Senate Bill 1003 as amended be retained on the calendar. All those in favor vote aye. All those opposed vote nay. Appears the ayes have it. Do have it. Division's been called. Members, all those in favor of retaining the bill on the calendar, please stand up. Okay. Now, all those against, please stand up. Members, with your vote of 25 ayes, 28 nays, the motion has failed. So we're going to go to a roll call vote. Those in favor vote aye. Those opposed vote nay. Don't vote until you hear the bell. The chair recognizes Speaker Mesner.
Thank you, Mr. Chairman. I rise to explain my vote on this motion.
Please proceed.
Mr. Chairman, members, this came at the request of the bill sponsor. The bill sponsor wanted it retained on Cow because there was not agreement with the amendments being added to her bill. You guys, most of you have been through this drill. You know what it's like to not have your bill moving forward in the way that you want. She can, of course, stop the bill at any time, in which case not only will the whatever amendments get on that she doesn't like die, but the underlying bill will die as well. So I would encourage members to give the bill sponsor more time to work out the proposed amendments. And so I would ask for you to support the motion simply to retain it on Cow so we have another shot at it another day. I vote aye.
Representative Espinoza, how do you vote? Representative Rivero, how do you vote? Members, with your vote of 30 ayes, 28 nays, the bill is retained on the calendar. Clerk will read the next bill on the calendar.
Senate Bill 1114,